Hi, good afternoon, everyone. We're just waiting about 1 more minute to let more attendees dial in. Thank you for your patience. We're just going to give 1 more minute because we know we have a few more people that have RSVP'd that we're waiting on. All right, thank you for your patience, everyone, and good afternoon. This is Meredith Higashi. I'm the Deputy Director at NAPABA. We're really excited that you'll all be joining us for our 5th annual Lobby Day to take place later this month, which is Asian Pacific American Heritage Month, and our Lobby Day is on May 18th and 19th. Lobby Day is one of NAPABA's signature events, and your presence at Lobby Day is really critical to advancing NAPABA's policy goals and expanding our collective impact as members of the APA legal community. So thank you again for your participation. As background, NAPABA's policy work is driven by our committees who propose resolutions. Our Board of Governors reviews and adopts the resolutions that guide us in our policy advocacy. All of these resolutions are accessible for your review, and I will be providing that information later in this webinar. So this year we've selected 3 core policy areas to focus on in our Lobby Day efforts. These issues are voting rights, immigration reform, and racial profiling. During this webinar, you'll be hearing from leaders in the APA legal community who are experts on these issues. They're going to provide background on the issues and guidance on how to advance NAPABA's policy priorities during Lobby Day. We're also going to provide you with an overview of the Lobby Day schedule and what to expect, as well as information to help you prepare for your visits with legislative offices. During the webinar, all participants are going to be muted, but you can pose questions at any time by using the Q&A feature on your webinar toolbox. Just click on the Q&A button on your screen and enter your questions into the text field. And at the end of the speakers' presentations, we will be addressing as many of your questions as possible in turn. And any questions that we don't have time to respond to, we will collect and make sure to provide responses to via email to all of the participants. If you happen to encounter any difficulties with the Q&A feature, you can also alert NAPABA staff at aasaria@napaba.org. With that, let's turn to our issue briefings from our guest speakers. Our first speaker is Jerry Vattamala, who will discuss voting rights.
Thanks, Meredith.
Oh, sorry. Go ahead, Jerry.
No, were you going to do my bio? Feel free.
Jerry's a staff attorney with the Democracy Program at the Asian American Legal Defense and Education Fund, ALDA, in New York. And Jerry's more comprehensive bio, as well as the bios of all of our presenters, are on your slides for further background. Jerry, take it away.
All right. Thanks, Meredith. See, I was a little bit eager there. Sorry. Welcome, everyone. Thanks for joining this webinar. I'm going to be talking about the Voting Rights Amendment Act, what happened in Shelby County v. Holder, which was decided about 2 years ago, 2013, and the implications and what you all can do to help us out on Lobby Day. So first off, voting is different. The slide here just shows 4 people that were killed trying to advance voting rights back in the 1960s. 2 of them in that missing FBI poster, on either side, on the left and the right, they're both 2 young people from New York that traveled down to Mississippi the summer of 1964, Freedom Summer, to register black people to vote in Mississippi. At the time, only 3% of black people in Mississippi were registered to vote. For their efforts, they were murdered, along with James Chaney, who was only 18 years old. And on the right there is Viola Liuzzo, who was a little bit lesser known. She was actually the only white woman killed in the entire civil rights movement, and she was murdered for trying to register black people to vote as well. Next slide. So we're going to cover Section 5. Some of you may have heard about this. It's a key provision of the Voting Rights Act. We're going to discuss what it says, what it requires of jurisdictions, and some of the other requirements around Section 5. The next slide, please. So, 1964, the civil rights workers were murdered. Some terrible things were happening in the South. It spurred Congress to pass the Voting Rights Act of 1965, a really comprehensive act by Congress to protect voters across the entire country from intimidation and racial discrimination. One of the key provisions was Section 5. Now, what Section 5 said was that if there was a history of discrimination in a certain state or jurisdiction, then that state would be, quote unquote, covered by Section 5. And if a state or jurisdiction was covered under Section 5, then every single voting change that was contemplated or going to take place by a jurisdiction would first have to be pre-approved or pre-cleared by the Department of Justice or the District Court in Washington, D.C. This was obviously a very onerous burden on the jurisdictions. Right off the bat, 9 states in the South were covered in their entirety. Certain counties in other states were also covered. But this didn't apply to every state and every county across the country, only these states that had a history of discrimination. Now, the way they determined if the state had a history of discrimination back in 1965 when this law was passed was looking at voter registration rates. Okay, so whenever a state that was covered, including the 9 states that were in the South, if they want to make any change, that means a poll site change, a change to the ballot, a change to the way voters register, any other requirements that affected voting, anything at all, it had to be pre-approved or pre-cleared by the Department of Justice or the District Court in Washington, D.C. Okay, next slide. Now, unfortunately, there's many times that jurisdictions said, well, we don't need the federal government to pre-approve our changes. We'll try and go ahead and do our changes anyway. If the jurisdictions did try that, they could be preliminary enjoined from that type of action because Section 5 required that pre-approval before any changes were able to take place. You can see here on the slide. And it was never intended to be something that was permanent. It originally, when it was passed, there was a certain period of time where it was only going to be enforced, and when that period of time expired, then Congress could reevaluate whether it should be extended further. Now, that's not the entire Voting Rights Act. That's only Section 5, okay? Because Section 5 is this really, as I mentioned, onerous burden on the jurisdictions. It's an extraordinary step taken by Congress to prevent discrimination in certain parts of the country that had that history. Next slide, please. Okay. Another provision of the Voting Rights Act is Section 2. Now, Section 2 is permanent. It doesn't have to be renewed every certain number of years. It's permanent. It's a part of the Voting Rights Act, and that prevents discrimination by jurisdictions on the basis of race. So an example of that would be unfair redistricting, or segregated voting lines, overt and explicit racial discrimination, as was often the case in the South. Those type of things were covered under Section 2. Unfortunately, many of the things covered under Section 2 are actions that you bring after the discrimination has already occurred. So once you lose your right to vote, it's gone forever. And Section 2 allows individual voters and groups of voters to bring actions, but many times it's after the discrimination has already occurred. And many times the litigation is very, very expensive to bring an action on your own as an individual voter, especially if it's a redistricting action. The great thing about Section 5 is that the burden was not on the voters, but it was on the jurisdictions. The jurisdictions had the burden to prove that their voting change was not going to have a discriminatory effect on voters of color. Next slide. All right. So unfortunately, conservative groups had brought challenges to Section 5 every single time it was renewed, starting from 1965, when it was renewed again and again and again. First, it was shorter periods. The last time before 2006 was in 1982. In 2006, there was the Voting Rights Act Section 5 had expired, and it was time to renew. There was extensive hearings done by Congress. Do we still need Section 5? Is it still necessary? We're not in 1965 anymore. Do we still need this onerous provision? Overwhelmingly, and you never see this, 98-0 in the Senate, and almost unanimous in the House. There's very few members of the House that actually voted against the renewing Section 5. It was overwhelmingly renewed for another 25 years. Since then, there was one challenge in 2009, challenging the constitutionality of Section 5, basically arguing that Congress exceeded their authority when they renewed Section 5 in 2006. That case in 2009 basically punted the question, didn't actually address it, but it allowed Section 5 to still stay in force. That brings us to Shelby County v. Holder, which was brought by a county in Alabama that again challenged the constitutionality of Section 5. So rather than ruling whether Section 5 was constitutional or not, the Supreme Court basically said the coverage formula was unconstitutional. And basically, by saying the coverage formula was unconstitutional, that nullified the effect of Section 5. Because if Section 5 is still allowed to be constitutional, but no jurisdictions are covered, it's basically worthless. The analogy is basically having this amazing car, but someone taking away the keys, right? You're not able to use Section 5 at all now because no jurisdictions are covered. So we went from a situation where we had numerous jurisdictions, again, 9 states in the South completely covered, and certain counties in other states that had to go through the Section 5 pre-clearance process. Now, after Shelby County, nobody's covered. There's no Section 5 usage anywhere. So, for example, in Texas, they had a voter ID law that was challenged under Section 5. Voters were successful in showing that the voter ID law was discriminatory, would have discriminatory impact. The district court actually struck down the voter ID law, said it did not satisfy pre-clearance requirements under Section 5, so they were prohibited from implementing their voter ID law. Literally hours after the Shelby County decision, Texas reinstated their voter ID law. So it shows you what the immediate effect was. It's basically, there's no more rules now. We don't have to follow Section 5. We can do what we want, and there's really no consequences. The next slide, please. It's great dissent from Justice Ginsburg. Basically said, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. And I thought that was a great line because Section 5 has worked amazingly for all communities of color, and that basically worked against it in the minds of some members of the Supreme Court, basically saying that's not necessary anymore. Next slide. One thing I want to quickly mention is the Voting Rights Act was equipped with something called a bailout provision. And that basically states that, okay, if your jurisdiction is covered under Section 5, you may argue, well, you know what, again, we're not in 1965. This thing is not, it was never meant to be permanent. Bull Connor is dead. We shouldn't be penalized for eternity because of our history. Well, the Voting Rights Act has a bailout provision that says if your jurisdiction can show that it has no voting rights violations within the last 10 years, your jurisdiction can bail out of coverage, and you would no longer be covered under Section 5. Every single jurisdiction that has ever applied for a bailout, including a jurisdiction that applied for a bailout during the pendency of the Shelby County case, has been granted the bailout. Every single jurisdiction. In my mind, that was such a great provision because that shows that the Voting Rights Act in Section 5 would never, ever be outdated because jurisdictions could bail out if they showed no violations in the last 10 years. Why didn't Shelby County bail out? And why did they challenge the constitutionality of Section 5 rather than just bail out? Because they couldn't. They had numerous violations for the last 10 years. It's just a horrible decision. Okay, next slide, please. Okay, we could skip this. This is, as I was mentioning, every single time the Section 5 was renewed, there was a challenge by conservative, either states or parties, challenging this constitutionality of Section 5. This has been a thorn in the side of conservative parties and members of jurisdictions for a long time, and they finally won in Shelby County. Next slide. We've used ALDEF here in New York. We've used Section 5 to make sure that ballots that were translated were fully translated. Quick example. 1990, Chinese was covered under Section 203 of the Voting Rights Act, which required all ballots and voting materials to be translated into Chinese. The New York City Board of Elections translated the entire ballot except for the candidates' names. They refused to transliterate the candidates' names, obviously an important part of the ballot. We objected under Section 5 because New York City, 3 counties were covered under Section 5. The Justice Department agreed with us and said, no, New York City, you cannot decide to not transliterate the candidates' names. You have to do that under Section 5. And they were forced to transliterate the candidates' names, enabling 55,000 limiting as proficient Chinese Americans to have fully translated ballots. We actually used it a few more times to, one example is they tried to move a poll site in Chinatown after 9/11 without telling anybody. We objected under Section 5, and they were forced to keep the poll site at the same location. So it's not just something that only African American or Latino voters have used. Asian Americans have used Section 5 on 3 separate occasions very effectively. Next slide, please. So where are we now? As I mentioned, we have nothing right now. We have no coverage. No jurisdiction anywhere in the country is covered under Section 5. This slide shows you on the left the jurisdictions that were covered under Section 5 before Shelby County. And legislation was put together, a bill was put together called the Voting Rights Amendment Act to have some kind of coverage, okay? And under the formula, which I'll cover very briefly, only 4 states would be covered. So the problem here is you might be saying to yourself, wow, look at the difference. 4 states is not enough. Obviously, we need to have more states covered and more jurisdictions. We have the realities of our current legislature, right? We have to work with members of Congress, and this was the best we could do, the Voting Rights Amendment Act, and this is what it would result in 4 jurisdictions in their entirety, 4 states being covered. Next slide, please. All right, and I should mention that a new bill was reintroduced. It appears to be almost the same thing that was introduced in 2014. It's HR 885, and again, it's the Voting Rights Amendment Act. And what this basically says is the new coverage formula would not look at voter registration rates as the old coverage formula did. It's looking back at violations, Voting Rights Act violations in the last 15 years. So if there are 5 Voting Rights Act violations in 15 years, the state would be covered, and Also, if there's 3 violations in 15 years, or 1 violation and persistent low minority turnout for local jurisdictions, that would be like a local county. All right. Now, the problem here with these violations is many times jurisdictions will settle, or they'll end up with a consent decree, and there's not a final judgment against them. The 5 VRA Voting Rights Act violations, those have to be actual judgments against them, final verdicts, which is a challenge for us. But again, this is the best that we could do. And this would not expire the way Section 5, as I mentioned, had to be renewed every time. This would be a continuing rolling metric that, I'm sorry, my computer screen just went blank. This would be a rolling trigger, so that with any 15-year period, you would look back at the Voting Rights Act violations to see if they met those minimum thresholds. Next slide, please. All right. So, other things some good things in this Voting Rights Amendment Act. Any changes within 180 days of an election have to be there has to be notification to the public. There is a mechanism for preliminary injunctions by the Department of Justice. DOJ can send observers to jurisdictions that have bilingual requirements, and it actually makes the bail-in requirement a little bit easier because discriminatory intent does not need to be shown. And I should mention, bail-in is really, it's what it says, is the opposite of the bailout. It would actually allow jurisdictions to be bailed into coverage. So jurisdictions that were not originally covered, they could be bailed into coverage. So that's where we're at. The best that we can do right now is the Voting Rights Amendment Act. It would result immediately, if it were to be passed, in at least 4 jurisdictions in their entirety being covered, 4 states in the South. But it also has the potential to allow other states or jurisdictions in the future to be covered if they have Voting Rights Act violations. Again, it's not perfect, but it's better than nothing. And it's really the best that we could do as all the organizations that were involved in the process of scrambling to try and find some kind of new coverage formula. This is really the best that we could do with the legislature that we have, and it's better than what we have right now, which is nothing. So we need something, and we have the momentum of this being the 50th anniversary of the Voting Rights Act that hopefully can spur the legislature to pass this act, this bill, the Voting Rights Amendment Act. Next slide, please. All right. Yeah, and now that's the spiel. So I'm happy. I think we're doing questions at the end, but if anybody would like me to clarify anything or anything like that, I'm happy to do that.
Great. Thank you so much, Jerry. Next up, we have Erin Oshiro on immigration policy. Erin is the Senior Staff Attorney for the Immigration and Immigrant Rights Program at Asian Americans Advancing Justice, AAJC, in Washington, D.C. Erin?
Hi, thanks, Meredith. Good afternoon, everyone. I just want to quickly thank NAPABA for inviting me to join today's presentation. NAPABA is a really strong partner of ours on immigration advocacy, and I'm excited that this will be a topic for this year's Lobby Day. So I just wanted to give some background today on what's happening with immigration reform right now, what's at stake for the APA community, and suggest some messaging for your advocacy later this month. Next slide. So just briefly, for those of you who are maybe less familiar with the different statistics about our community and how immigration impacts us, immigration reform really affects our community in a number of ways because the majority of Asian Pacific Americans are immigrants. We're nearly 2/3 foreign-born, which is a greater percentage than any other racial category. We come to the U.S. through different ways, and we're represented kind of across the immigration spectrum. So we have a significant number of our community members are undocumented. It's about, almost 10% or so, or a little over 10%. We are also come here as employers and as employees and as business owners. we're the majority of H-1B visa holders, and those are temporary high-skilled workers. We come here as immigrant entrepreneurs. At different points in history, our community has come over in large numbers as refugees. And in the recent years, the largest refugee groups have been coming from Burma and Bhutan, so those are some of our emerging communities. We also come here, as students on family-based visas, and we are also a lot of our community members are long-term legal permanent residents. So we're kind of all across the board in terms of the immigration system. Next slide, please. So just to kind of give people some context and the state of play, what's happening now in immigration, and haven't we been talking about immigration reform for forever? So the last Congress, the 113th Congress, we came closer than ever to achieving a legislative solution. We passed a bipartisan bill in the Senate that had a number of things that our community wanted, but also had some hard compromises. Ultimately, that effort died when the House failed to take up a bill before the last Congress ended. As a result of tremendous community pressure, including from Asian Pacific Americans across the country and other grassroots leaders and advocates, President Obama and his administration decided to take action. In November of 2014, President Obama announced a series of executive actions. I would say there were probably close to 24 or so components of what he announced. And these basically are things that is within the administration's powers in terms of policies and practices that they can implement on their own. The president's actions were premised upon the executive branch's traditional power of prosecutorial discretion, right, as sort of a law enforcement agency that they can decide, whom to prioritize for immigration enforcement, how to direct their resources, and to kind of best prioritize, their time and attention. Given our limited time today, I'm just going to highlight a couple of the changes announced by President Obama. Next slide, please. So the first thing I want to talk about is deferred action. Some of you may be familiar with something called DACA, Deferred Action for Childhood Arrivals. This was a program put in place by the President originally in 2012, and this extended essentially temporary protection from deportation and also provided work authorization to certain eligible undocumented immigrants who had come here as children. These are generally called them the Dreamers. Originally for that original program, as it was announced in 2012, about 100,000 or so APAs were expected to benefit from that program, kind of based on the best estimates of our community. Not nearly as many community members have applied for the existing DACA program. Only about a third or so of eligible APAs have applied for that. But in November, the President announced that the Department of Homeland Security would be expanding the DACA program to more young adults. The original program had an age cap of 31. They would be lifting that age cap. And then they would be creating a similar program for the undocumented parents of U.S. citizens and legal permanent resident children. So, these community members who have deep ties to America and who have children here. It was expected that, with the expansion of DACA, the new program for parents, about another 350,000 APAs would benefit from those two programs. So, a significant part of our community would stand to get relief. Unfortunately, those two programs, the expanded version of DACA as well as the program for parents, DAPA, are both on hold. In February, a district court in Brownsville, Texas, issued a preliminary injunction putting those programs on hold because of a lawsuit that had been filed by a number of states. 26 states had sued the federal government, and the injury that they're asserting is that there will be costs and that the states will have to bear if those programs move forward. The district court found that the state of Texas, at a minimum, had standing, and they held that the federal government had not followed rulemaking procedures under the APA. So right now, those two programs are on hold, and kind of where we are at in the litigation, there is discovery taking place at the district court level, and then Department of Justice has appealed the initial injunction to the Fifth Circuit. So the Department of Justice has requested that the Fifth Circuit grant a motion to temporarily lift the stay while the appeals play out in the courts. A couple of weeks ago on April 17th, the Fifth Circuit panel had oral arguments on DOJ's motion, and they haven't ruled yet, so we'll have to see how that plays out. I don't think people are hopeful that the injunction will be lifted by the Fifth Circuit, but we'll see how that moves forward. Also, there have been attacks in Congress, and I'll get to this a little bit more, from the current Congress trying to attack the president's authority to implement these programs, to block funding that would help the Department of Homeland Security move forward with the programs. None of those efforts have been successful, but they have taken up a lot of kind of time and energy for advocates based here in D.C. Next slide. The other kind of key component of what the President and his administration announced in November had to do with immigration enforcement and discretion. So, we see here that with this administration, large numbers of our community have been deported. Overall, this administration has deported more than 4 million immigrants and community members, so they have set records in terms of their enforcement actions. And our community has sort of been disproportionately impacted because of laws passed in 1996 that really hurt community members who might have had criminal backgrounds, and it really restricted, their legal remedies in terms of the deportation process. There is really no judicial discretion for community members who have criminal histories and are facing deportation. And this has really hit our Southeast Asian community members in particular. As part of the November announcement, the Department of Homeland Security set forth new enforcement priorities for, kind of who they will be targeting for detection and deportation. It's not clear how much our community will stand to benefit from those changes because legal permanent residents who have certain criminal histories are still a priority for deportation, and a lot of Southeast Asian folks who are at risk of deportation fall into that category. Another thing that the Homeland Security announced is that they would be replacing something called Secure Communities, which is a local federal program where basically local police officers and sheriffs are enlisted to help enforce immigration laws. It was a controversial program that we felt led to a lot of racial profiling and targeting of community members who otherwise don't pose a risk to our communities and shouldn't be priorities for deportation. That program has been ended, but they are putting in place something called a priority enforcement program, which focuses more on people who have been convicted of crimes rather than kind of catching people at the beginning of the process when they have just been arrested. That has not been fully rolled out yet, so we're sort of in a wait and see on those two programs. Next slide. The last thing I'll mention about executive action and what it means. So one other key component of what the President announced had to focus on kind of, the business side, the economic side of our immigration system. So a couple of things that came out in November. The administration announced it would be finalizing a rule that would provide work authorization for the dependents of H-1B visa holders. So H-1B visa holders are temporary workers who are here in the U.S. They are primarily from Asian countries, specifically South Asia and South Asian countries and China. So work authorization for their spouses has been something we've been pushing for a long time. They finalized that rule, but 2 weeks ago a lawsuit was filed. I don't think anything has happened other than the suit being filed, but that's another kind of improvement that might be at risk. The other thing is that there will be more options for entrepreneurs who are seeking to come to the U.S. And for students who are foreign students who are here in the U.S. and are trying to stay here. The majority of foreign students and entrepreneurs who come to the U.S. are from Asia, and so our community stands to benefit from kind of these expansions and improvements on the business side of things, and the kind of the foreign student side of things. Next slide. So, what does this mean then for your advocacy later this month? So the important thing to know about what the President has done is that, while these changes and actions are quite significant and really will benefit, our community as well as other immigrant communities, they are only stopgap, or temporary measures. Deferred action for childhood arrivals or the similar program for parents, it is temporary. It's a 2-year program or a 3-year program if it's able to be expanded, but it leads to nothing. It does not lead to a green card. It doesn't lead to citizenship. Changes to our family-based system or our employment-based system need to be done through legislation. So we are still seeking, permanent legislative solutions that will create a path to citizenship for undocumented individuals, that will strengthen and reunite families more quickly, that gets our businesses the workers that they need and also protects workers, and really restores and strengthens due process in our immigration system. So when NAPABA members are on the Hill in a couple of weeks, I think that it would be important to talk about why we still need immigration reform. Along with the VRA, this year is the 50th anniversary of the Immigration and Nationality Act. And this was basically the first time in our history when Asian immigrants were able to come to the U.S. and kind of got rid of all of kind of the last vestiges of race-based restrictions and quotas in our immigration system. So it's kind of a key moment when we should be talking about these issues. When you're on the Hill, though, I think that your messaging will depend a little bit on which type of offices you are meeting with, and they largely break down by party lines. So just quickly, for Democratic offices, I think it would be helpful for NAPABA members to educate members of Congress or their staff about how beneficial executive action is for the Asian Pacific American community, and encourage those offices to engage with our community in their districts. So, for example, they could host an educational session on DACA. And we should also support them, thank them for supporting executive action if that is the case. Not all Democrats were on board with the president's actions. We also should express concern about efforts in Congress to roll back executive action and encourage members to be vigilant about those types of bills or amendments. We have seen a lot of those already this Congress. On the flip side, for Republican offices who by and large dislike executive action and say it is presidential overreach and the president had no authority, I think it is an opportunity to do a little bit of education about why the president's initiatives are good for our community, but then pivot quickly to how it is still Congress's job, to fix our system and to put in place long-term lasting solutions that meet the priorities of Asian American communities and that meet our needs. And if people are encountering pushback about executive action, it could be just that we agree to disagree, and that it's up to the courts now to decide, whether the president acted lawfully and whether, some of his programs will be able to move forward. But really to try to keep the messaging on what it is Congress needs to do and what we, want as a community to see in terms of immigration reform. I'll stop there because I know we're a little bit short on time and happy to take questions later.
Thank you, Erin. Next, we have Navdeep Singh, who will focus on the issue of racial profiling. Navdeep is the Policy Director at the Sikh American Legal Defense and Education Fund, ALDA, in Washington, D.C.
Good afternoon, everyone, and want to thank you all for joining us today, and thank you for being part of the NAPABA team to raise our voices on these important issues. Thank you to NAPABA and Meredith and her team for bringing us all together, and also to my colleagues, Jerry and Erin, for those wonderful presentations. So, we're here today to talk about racial profiling. Well, what is profiling? Hit the next slide. As you can see, profiling is something that affects all areas of life, whether it be immigration, to law enforcement, to national security. The racial profiling is targeting based on the perceived race, ethnicity, national origin, religion, gender, or sexual orientation by law enforcement or government or state actor. There are a couple of things I want to point out in the definition of what profiling is. And I want to first say that we tend to use as advocates the term racial profiling to cover profiling in any sense of the word. It's a little bit of shorthand, which is understood on the Hill when you use the term racial profiling. First thing is that it's perceived characteristic of the individual who's being profiled. It doesn't actually have to be what their actual race or ethnicity is. Second is that strict scrutiny, which applies to racial questions of racial classification, still apply in cases of racial profiling. But it also means that if you have, for example, a specific suspect description which indicates the individual's race, or is as part of a specific time-bound intelligence enforcement activity, national security enforcement activity, you can still use racial profiling. You can still use the racial characteristics. You cannot use racial profiling, though, which is targeting exclusively based off of protected characteristics. Next slide, please. So what we know is that profiling doesn't work. It's an ineffective use of resources. It has law enforcement and national security folks end up casting too wide of a net instead of the surgical net that they want, precision that they want to use in stopping crime or protecting the homeland. It damages individuals and communities. It creates a lot of mistrust with between law enforcement, and that then means that folks are less likely to come forward to law enforcement when they may need help in their own situation. Next slide, please. So the context is profiling after 9/11. As you may know, during the Clinton administration, they actually did a study to look at traffic stops. And what they found was that there was a higher stop rate for Black and Hispanic individuals, and but they also had a lower seizure rate for contraband as compared with members of the white population who were also stopped. That has led on to has affected how we look at profiling now after 9/11. After 9/11, we continue to be haunted by the legacy of internment of Japanese Americans, and that meant that what it didn't stop is that communities perceived to be the other, Arab, Muslim, Sikh, South Asians particularly, were subject to stopping at airports, being pulled off of trains, warrantless surveillance. For example, what the NYPD did, trying to send in informants in the Muslim communities, surveilling them without warrants, and what they called mapping of communities throughout New York, and created a sense of suspicion focused on these communities because of their perceived race, ethnicity, national origin, or religion. It is also actually these powers have been used, these expanded powers of surveillance have been used to target Chinese, Russian, African American, and Latino communities as well. We saw an increase in programs conducted by federal and local law enforcement agencies, Secure Communities, which Erin mentioned earlier, and another program called NSEERS, which is a federal program that meant that any visitor from about 25 largely Muslim or Arab countries who was above the age of 16 and a male had to go under special registration with the United States government. And as we mentioned, profiling still continues to impact other communities, as we see in the news today. Next slide, please. So what has been some executive action on racial profiling? In 2003, the Bush administration, in response to a statement made in his 2001 State of the Union, issued racial profiling guidance through the Department of Justice, which applied across their work. Now, in December of 2014, the Obama administration, under Attorney General Holder, issued revised guidance. This new guidance expands the protected classes. It's no longer just focused on questions of race and ethnicity. It includes things like race, national origin, religion, gender, and sexual orientation of select protected classes. But there's some limitations to it because it is federal guidance issued by the Department of Justice. It applies only to federal law enforcement activities. It does not apply to state and local agencies, and there's a lack of clarity as to how it actually plays out in joint task forces and fusion centers, something which has increased in importance in the post-9/11 era. And furthermore, it specifically exempts national security and border contests, and specifically says that the TSA, CBP, and certain FBI activities are exempt from this prohibition on profiling. Next step, please. So how do we get across those problems? Those limitations on the federal side, those limitations on the use of profiling. one of the best tools we have is the End Racial Profiling Act. Now, what's interesting is this act was actually first introduced in June 2001, and there was bipartisan agreement around the bill. There were bipartisan sponsors on the bill, and it wasn't a partisan issue. However, as we all know, September 11, 2001 changed the context that law enforcement and national security began to be viewed. That meant that there was a lot more concerns about making sure that law enforcement and national security agencies and officers did not have their hands tied in any way and could react immediately using any means necessary to protect the homeland. So the current bill was introduced in April 2015, just last month, by Senator Cardin and Representative Conyers. And it's important to note that the bill has actually been introduced every year, every congressional session since its original introduction. It currently stands at 15 sponsors in the Senate and 88 co-sponsors in the House. It is important, though, to note that currently all of the sponsors in the House and Senate are all Democrats. Next slide, please. So what does IRPA do? It prohibits profiling by federal, state, and local Indian tribal law enforcement authorities based on the basis of race, religion, ethnicity, and national origin. It mandates training on racial profiling and data collection. Data collection is really important because if we don't have that, we can't get our hands around and be aware that there is a problem or a disparate impact on our community. It creates a private right of action for victims of profiling to seek redress. Next slide, please. And it authorizes the Department of Justice to provide grants to develop best practices to discourage profiling and, most importantly, using Congress's power of the purse to withhold grants from agencies that are not complying with IRPA. It's actually that power of the purse which is one of the best tools that we have from a federal level to affect change on the state level. And finally, it requires the Department of Justice to conduct periodic reports to assess any discriminatory policing practices by various levels of law enforcement. Next slide, please. Yeah. In the interest of time, please do submit any questions if you have them about any of the information we've covered. But I want to give you a little context as you prepare for your Hill visit. Two things you can do are ask, and as Erin rightly said, what you say is going to very much depend on the offices that you're visiting. And you may be in a situation where you are going to be talking more about educating of the impacts of profiling, its inefficiencies. And in other cases, you're going to be more explicit at thanking individuals for their sponsorship or asking them to support and sponsor IRPA. There is still believed to be bipartisan agreement around the need for the legislation. And when you ask someone to support and sponsor, they may be unwilling to sponsor it, but they may be saying, you know what, we will go ahead and we will support efforts to at least bring it to the floor for a vote. Important to note that one of the asks that we as a civil rights community have is that Congress, both the House and the Senate, hold a hearing on the bill. The bill thus far has not had a hearing even though we're now coming on almost 15 years of it being actively considered legislation. It's important to note when you speak to individuals and staffers on the Hill that the bill does not limit law enforcement's ability to use the characteristics as part of specific suspect description. That, as we all recall, is the strict scrutiny classification which the court has found is necessary in the use in determining whether or not racial descriptions and the like are permissible. The final thing that when you speak to folks on the Hill is to remind them that racial profiling is ineffective. It's been proven and is acknowledged by law enforcement, including Republican and Democratic administrations, that racial profiling is an ineffective law enforcement tool. And we all know from our own experiences within the Asian Pacific Islander American community that it creates community mistrust and makes it harder for law enforcement to develop that strong relationship necessary in order to help serve our community. Thanks a lot, and if you have any questions, please feel free to submit them.
Great. Thank you, Navdeep. As I mentioned at the beginning of this webinar, we do have some time for Q&A, and if you have a question, please enter it into the Q&A box. Right now, we just have one question, and it is, will the PowerPoint presentation be made available? The answer is yes. This entire webinar is being recorded, and the link to this recording will be shared with all of you, as well as the PowerPoint separately, if you would like. We'll send that information out along with some follow-up materials on this webinar and the speakers' presentations to all of you. Okay, so at this time, it does not seem that we have other questions, but again, a reminder, if you do have some follow-up questions, please feel free to email NAPABA staff, and we will follow up in writing over an email to all of the participants with our responses. Next, we want to briefly turn to some information about what to expect when you are in DC for our Lobby Day. As you know, our event spans 2 days. First, we are going to be conducting an in-person training on the afternoon of May 18th, and this training is going to supplement the material that you've heard in this webinar. And again, you'll hear from experts on the issues and also have a chance to meet with your lobbying teams. During this training, you will also be given information about your specific member visits. Following the training, NAPABA is hosting its Asian Pacific American Heritage Month Congressional Reception, and we will be joined by members of Congress, including our Honorary Chair, Senator Mazie Hirono, and the Congressional Asian Pacific American Caucus Chairwoman, Judy Chu, along with congressional staff and other leaders in the APA community. The next morning on May 19th, all participants will meet for a welcome breakfast and receive more training that will focus on key tips for effective lobbying. We'll cover logistics and provide some time for all of you to strategize and plan your meeting agendas with your lobbying teams prior to departing for your meetings later that day. Generally, participants are going to be divided into teams of 4 or 5 people based on region, and each team is assigned a leader. After the day's meetings, all participants will meet for a happy hour, and we'll be doing a collective debrief and conducting follow-up steps at that time, discussing follow-up steps. So many of you will want to know how to prepare for your Hill visits, so I'm just going to cover some basics about what you can do and what to expect. And again, we'll go over more of the ins and outs of effective lobbying visits during the in-person training in a couple of weeks. But important information for you to know right off the bat is that you do not need to be, nor will congressional offices expect you to be experts on the issues. You won't need any information beyond the trainings and the materials that we're providing for you. And those materials are going to include background information on your congressional members and their positions on various issues, as well as some talking points that can guide you in your meetings. I think what's most valuable during these meetings are really your perspectives as attorneys and as constituents of the communities the congressional members represent. And so to the extent that you can incorporate personal experiences or stories that illustrate how these issues impact you, people you know, and your community into your discussions, we really encourage you to do so. In the meantime, before we all convene in DC for Lobby Day itself, we are going to follow up on this webinar with background materials, as I mentioned, so please keep an eye out for those over email. In addition, we encourage you to review NAPABA's policy resolutions on these issues. NAPABA has passed resolutions that are directly on point on voting rights, immigration reform, and racial profiling. These resolutions can be found on our website, and the link is included in your slides. So if you have further questions for NAPABA staff, please don't hesitate to contact us. Arya Joy Asaria is the main contact, and her email address is up on the screen. This concludes our pre-Lobby Day webinar. We again want to thank all of the speakers, as well as extend appreciation to the rest of NAPABA staff, including Arya Joy Asaria and Dana Chapnick for their preparation for this webinar. And to all of you who are participating, thank you very much for joining us, and we'll see you at Lobby Day.